Welcome to The Explainer. I am absolutely thrilled you're joining me today because we're jumping right into a completely fascinating, objective look at a deeply complex piece of legal history. We're going to break down Pakistan's 1979 Hudood Ordinances and then the massive 2006 legal reforms that eventually followed. You know, legal frameworks are kind of like the operating systems of a society, and when you actually pop the hood to see how the mechanics work, it's just astounding. To really wrap our heads around this, we need to ground ourselves in the history for a second. We're analyzing official state statutes that were promulgated way back in 1979 under General Zia-ul-Haq. This was all part of a really sweeping Islamization process aimed at bringing Pakistan's legal code directly in line with historical Islamic jurisprudence. So we're literally looking at the exact legal codes that governed millions of people for decades.
All right, here's our agenda. We'll be looking at the foundations, property crimes, life and harm, intoxicants, Zina and Qazf, and finally, the 2006 reforms.
Let's start with Section 1, Foundations, Had versus Desir.
Okay, to make any sense of these specific crimes, you absolutely have to understand the bedrock of the 1979 ordinances. It's a dual-track system of punishments. On one side, you have had. These are considered divinely ordained by historical texts. They are fixed, they're severe, and they can't be changed. But, and this is a huge but, they require an incredibly strict, almost impossibly high evidentiary standard to actually enforce. Then on the other side, you have ta'zir. These are discretionary, state-level punishments decided by the penal code whenever those strict conditions for had just aren't met. So really, understanding whether a crime qualifies for had or falls back to ta'zir is the whole linchpin of this legal universe.
Moving on to Section 2, Property Crimes. Specifically, theft, known as sarqa, and haraba.
The ordinances basically divide property crimes into two buckets. The first is secret theft, or sarqa. Now there's a very specific number you need to know here, 4.457. This represents 4.457 grams of gold, a threshold known as the nisab. For a theft to even be considered for a severe had punishment, like amputation, the value of whatever was stolen must equal or exceed that exact amount. If it's even slightly less, the crime automatically drops down to the lesser discretionary ta'zir punishment.
But honestly, the value isn't the only catch. The property also has to be stolen from a hers. What's a hers? Well, it means an active arrangement made for the custody of property. Think about the logic here. If you smash a window and steal a wallet from a locked car, you've breached a hers. But if you just find a wallet sitting in the middle of a public street and take it, that's not breaching a hers. And without breaking a hers, you simply cannot apply the had punishment.
On top of all that, there's a highly specific list of exemptions where the severe had punishment is completely suspended. For instance, if you steal from a spouse, or if a guest steals from their host, had doesn't apply. Stealing wild grass or perishable food, no had. But most importantly, if you steal out of an extreme, genuine fear of death by hunger or thirst, which is a legal concept called istrar, or if someone literally forces you under threat, called ikra, the had punishment is totally off the table. The system just defaults right back to ta'zir.
So how does that standard secret theft compare to haraba? Well, sarqa is all about secrecy. The thief is really hoping the owner doesn't notice. Haraba, on the other hand, is a violent show of force. We're talking highway robbery, where the offender attacks, restrains, or actively terrorizes the victim. Because haraba breaks the public peace in such a violent way, the had punishments here are completely different and far more severe, potentially even including cross amputation, like removing the right hand and the left foot.
Next up, Section 3, Life and Harm, Qisas and Diaq.
Now let's look at how the 1979 framework handled physical injury and murder. The entire system is built on two primary avenues of justice, and these choices are given directly to the victim or their legal heirs. Qisas essentially means retribution or similarity. Think an eye for an eye. Diaq, on the other hand, means financial compensation or blood money. If the victim or the family decides to forgive the perpetrator, they can actually opt for financial compensation instead of seeking physical retribution.
And just like we saw a strict threshold for theft, there's a quantifiable standard here too, 30,630 grams of silver. That is the minimum statutory benchmark value for diaq. It sets a very clear, quantifiable baseline for financial compensation when a human life is lost.
Now, to apply either qisas or diaq, the court first has to categorize the killing itself, and the ordinance breaks this into 4 specific types. Amd is a deliberate, intentional murder using a lethal weapon.
Shibaya resembles intentional murder, but maybe a non-lethal weapon was used, yet it still resulted in death. Kata is a pure mistake of fact, like a tragic hunting accident. And finally, Bisasabab is an indirect cause, say unlawfully digging a deep pit that someone accidentally falls into. So the offender's intent and the exact weapon used completely dictate how the law responds.
Section 4. Prohibition. The rules regarding intoxicants.
This brings us to the Prohibition Order of 1979. Now, the strict rule obviously prohibits consuming, bottling, or manufacturing intoxicants. But what's fascinating is how deeply pragmatic the law actually is when it comes to human life. Consuming an intoxicant is totally legally permissible if a person is under extreme duress. Remember that concept of istrar we mentioned earlier? If you absolutely need it to save your life from extreme hunger or thirst, or if it's a necessary medical treatment to prevent death, you're exempt. Preserving human life completely overrides the prohibition.
Section 5. Morality. Zina and Qazf.
Historically, this section became the most complex and heavily debated portion of the entire legal framework. The ordinance introduced two deeply intertwined concepts. First, zina, which was defined legally as unlawful sexual intercourse outside of marriage. And second, Qazf, defined as making a false accusation of adultery against someone without having the required legal proof.
This brings us right back to that dual-track system we talked about in the beginning. To actually apply the severe had punishment for zina, the evidentiary bar was set incredibly, astonishingly high. The court demanded either a completely voluntary confession with zero pressure or the direct eyewitness testimony of 4 adult male Muslims. On top of that, those 4 witnesses had to pass a strict court credibility test known as Tazke al-Shuhud to prove they were of impeccable moral character. If the evidence fell even slightly short, had could not be applied.
But here is where we hit a massive, tragic, historical complication. Under the 1979 framework, the crime of rape was classified under the Zina Ordinance as Zina bil Jabr, which translates to forced zina. This created a profound legal entanglement. If a victim of rape came forward but couldn't produce 4 eyewitnesses to the crime, the court couldn't technically prove the forced aspect. Tragically, in many cases, the victim's own report was treated as a confession to unlawful intercourse, or they were charged with Qazf for failing to prove the accusation against their attacker. This immense tension existed for decades.
Which leads us to Section 6, the 2006 reforms and the Women's Protection Bill.
Look at the timeline here. From 1979 to 2006, that is nearly 30 years. This procedural entanglement between rape and the strict evidentiary rules of zina just remained in place. It wasn't until 2006 that the legislature successfully passed a bill that was explicitly designed to resolve this exact tension and better protect citizens seeking justice.
The 2006 reforms were incredibly surgical. The bill entirely separated the crime of rape from the Zina Ordinance. It completely removed that requirement of 4 eyewitnesses for a rape victim. It transferred jurisdiction out of the religious courts and placed rape back under the standard Pakistan Penal Code, specifically sections 375 and 376. What did this mean practically? It meant that forensic evidence, medical reports, and circumstantial evidence could finally be used to prosecute the crime, carrying strict punishments of 10 to 25 years in prison or even the death penalty.
This whole journey from 1979 to 2006 leaves us with a really profound question to think about. How do complex legal systems balance the desire to implement rigid, historical texts with the urgent, constantly evolving need to provide practical protection and justice for their citizens today? The evolution of the Hudood Ordinances provides a fascinating real-world case study in exactly that struggle. Thank you so much for joining me on this explainer. I really hope it brought some clarity to a tough topic. Keep learning, keep asking questions, and I'll see you next time.